this is the continuation of the great presentation that was just done by Jay. While there's lots that can be gleaned from the winning cases, we often learn quite a lot from losses as well. And that's what I'll be going through in this half of the presentation. So we'll be looking at the 8 unsuccessful projects and focusing specifically on 2 that were, in my opinion, particularly interesting. So just a little bit of background. As always, when we get to this stage and we're actually looking at the cases themselves, there's a lot of limitations in terms of what information we have available to us. We don't know what was submitted in the original T661. We don't know really what was in the correspondence, and we don't necessarily have access to the actual testimony that took place. So getting to this point, it's a narrowed view of what happened, so it has to be viewed with a very different lens. But I also want to really emphasize before we start just how long it takes. So if you're considering going down this road, be cognizant that it can take quite a while for this to be resolved. In this case, it was 9 years before some of the projects reached this resolution. And it's always good to know who's involved. So the judge had been involved on 2 SR&ED cases recently, and so far it's not a great track record for whoever's going up with this judge. But I'll talk about why that's good to know and why looking at this case is really helpful. So again, in terms of the people that were on the stand, the CRA put forward 2 very well-credentialed individuals that were discussing their perspectives, not only as professionals in their field, but also as SR&ED consultants. BMQ put forward 2 witnesses from the company, again, very experienced individuals that had decades of background in this space. So this is one of those cases where you have 2 very, very intelligent groups discussing very granular points. And what came out of it is quite interesting. So the framework for this case, which Jay alluded to, and I'm going to go into it just a little bit more here before I talk about the losses, is how the judge laid out the ruling. So this judge, she was heavily reliant on Northwest Hydraulics, as most are, including listing out the 5 questions that we're all familiar with. What I thought was really interesting is she pulled a lot of her references from IC 86-4 R3. And for those who are newer to the program, this is what was in use up until about 2014. And because these projects occurred prior to 2014, that's why I would assume that she chose to use this particular policy information circular from that time. What we're looking at now is the SR&ED eligibility work policies, which in theory are the same, but as we know, there are some subtle differences, so just keep that in mind. What she did really well here as well, and this is useful for anyone who is in a difficult position of pushing this through a little bit further, she really carefully outlines the key concepts, including what is considered scientific or technological uncertainty, how a hypothesis is defined, and Jay talked a little bit about this, and Dave did as well, that overarching, overly broad hypotheses are not something she will be accepting, that she really did focus on the scientific method and then what is considered enough documentation, so formal reports and in some cases verbal testimony. However, there are limitations to that, and I will talk a little bit about that. So just quickly, I'm not going to go into quite as much detail about the concrete, as exciting as that topic is. I'm going to focus a little bit more on the policy points, but this was the first one that we talked about. So the study of permeability to chloride ions and durability with various pozzolanic additions and cement. So quite a mouthful, but the essential background is here. So in 2009-2010, the ministry added new requirement standards to concrete, namely a permeability threshold. So currently, or at that time, in order to meet concrete standards, there were 22 tests, and this was a new test that needed to be added, and all of them had to be passed in order for the concrete to be used. So a grace period of a few months was granted to the companies to give them time to do the tests that were necessary to demonstrate that their concrete mixes complied with the new standard. It happens all the time that these sorts of things come out, everyone's left scrambling, and that was the case with this organization. So Dave did a really nice job of putting up this little summary again that lays out the types of activities that would have been done. But as you can see here, we don't have a lot of information actually coming out of the ruling itself, likely because the judge didn't feel it necessary to really emphasize this because it was not successful. But what the judge did do is summarize the experimentation as she understood it. So in this case, BMQ made an inventory of its products, checked which ones met the standard, changed the mixing sequence, added adjuvants as required, and they selected the mixtures which complied with the standards. What's really important to note here is that BMQ didn't investigate the reasons why some of these mixtures did not meet the standards. So they went through, they figured out which ones did, that they could either use as is or modify slightly, but there was no further analysis as to why something worked or did not work. So the taxpayer position in this case was that data was missing and that it was collected by running these tests within the framework of the project, and it allowed them to reformulate some of its mixtures to improve them in regards to this particular requirement, so the permeability of chlorine ions. CRA obviously didn't agree, which is why we ended up in this position. And what their position was that existing mixtures containing known ingredients were tested. The techniques used to adapt the mixtures were also considered standard engineering techniques. The argument they made was the scientific method was not respected since no links between the mixtures were tested. So there was no logical sequence. They simply abandoned some when standards were not met, and instead of, again, trying to understand the causes of the failure. So the judge was very deliberate in her assessment here and put down what she observed through all of the information presented to her, which was that the notes, she noted that mixtures tested directly were not reformulated in any way. They also carried out the test to verify the effect of pozzolan on cements, but these are actually well known and well documented in scientific literature. And the mixing methods are fairly well known. Again, the taxpayer did try to argue that the use of a mobile concrete mixer introduces a degree of unpredictability, but as she states later on, that just wasn't enough to really indicate there was a technological uncertainty. So again, mobile concrete mixing didn't bring enough to the table in terms of introducing an uncertainty. She also put forward an interesting argument that she didn't believe that the ministry would introduce a new standard if they thought that companies couldn't meet it. In essence, she indicated that they hadn't convinced her that they'd followed the scientific method. So even though tests took place and they reviewed the results, the organization skipped from one mixture to another without an analysis of the reasons why the mixtures met the standards or not. And as a result, she was led to the conclusion that it can't be SR&ED because normal product characterization tests, so does it not meet the standards, have not actually created any scientific uncertainty. So these are the concrete lessons that I'd like to think comes out of this. So keeping good documentation that shows the thought process, including the analysis of why it worked or didn't work, is important in this context. So you want to have a really good foundation to build upon. When she goes through the analysis as well, she took a look right down to the level of the timesheets. And while we all know that an allocation method is possible, that's carefully outlined in the salary and wages policy under section 13.1, it's important to proof your timesheets because it will come up if you get to this level to see if some of the work being done is considered normal data collection. And it's really important as well, and we talked about this earlier on, and Jay covered this, that you have a really good foundation, that you're firm on what your technological uncertainty is by doing that due diligence at the beginning. So that was the first one that was interesting. And the second one was very much viewed with the same lens. So the second project was the improvement of quick-setting concrete. Someone has moved my screen and I can't see the slides and I don't know how to fix it. Thank you. And in this one, they were, again, looking at making repairs to a dam. However, the inputs contained in the mixture segregated. So something was going on, and the test results remained satisfactory in their laboratory and didn't match the problems that they were seeing on site by the client. So there was something definitely going on, and they didn't know what it was. Again, Dave helped provide this summary here in terms of what was done and what we can glean from the ruling itself. And it's very, very broad. So there are hints of uncertainties and key variables. There was definitely testing that was going on, but it's very light on what we would like to see in terms of benchmarks, objectives, uncertainties, and the tests themselves. That said, the judge did outline the experimentation, and her understanding of it was that after analyzing the various factors that could cause a mixture to segregate, such as the weather or the presence of vibrations, the only variable that the organization could find that was causing the separation was the local water. So in theory, any potable water should work, and it shouldn't have an impact on concrete unless organic matter is present. So they repeated the tests on site. They confirmed that the water was the problem, even though it was potable. They did not, however, specify what element in the water could have had this effect. So what they did, the taxpayer did, was they changed their process. So water was therefore delivered to the site to allow the work to be completed. And from now on, water to be used in this mixture at any site that they were working on in the future would be sent back to them so they can run some tests to see if it will work or not work. And if it won't work, then they will send out water that they know will work on site. So the taxpayer position here was they were aiming to determine the factors that might affect a mixture on the job site, which met standards when it was tested in a laboratory. And the new knowledge that they were arguing that they generated was the impact of water on concrete. Now, the CRA's position is, once again, that this was not experimental development. It was more along the lines of trial and error. So the mixture that was used was already known. Although a handful of adjustments were made, the steps that were taken were aimed at solving a technical problem, which is the term no one wants to hear as someone applying for the SR&ED program, that it was solved by trial and error, since BMQ used public data and experience of its staff to solve it, and problems encountered in this, Dave, could you go back to whatever slide I was just on? The problems encountered in relation to that were, let me go back. Okay, were part of the current practice. So the judge's rationale for the ruling, the loss, was that the taxpayer used current technological knowledge. There would have been uncertainty if they had convinced the judge that the probability of achieving their objectives or way to achieve them would not be known or determined in advance based on the experience or technological knowledge that's usually available. And the addition of colloidal agent to decrease segregation of the mixture are common techniques in the industry. So a lot of this was, again, standard, which they were not happy about having it assessed as this during the ruling, but that is really how it came across. Now, one of the other things that came up, and Jay talked about this a little bit earlier, was the importance of the documentation, and that testimony earlier was used to accept some of the projects. In this case, it worked against them because the testimony wasn't consistent with the contents of the 2661 form And what BMQ claimed in a letter they sent in November, again, we don't see that letter here, and the timesheets produced, that water wasn't really the focus of this project, and there was no mention of the tests that were carried out with the different waters. So that inconsistency was jarring from the judge's perspective. Again, they felt that it was more of a trial and error method because they didn't apply the scientific method, even though several hypotheses were put forward. And finally, the tests could be partially reconstructed using the documentation, but it wasn't possible to follow the thought process, how BMQ got to each of the conclusions and how that influenced subsequent iterations and subsequent tests. So if we think about the experimental process, so the test analysis conclusions, that wasn't captured in here. So again, the concrete lessons that came out of this, and I cited the different sections of the ruling. So do keep good documentation that shows the thought process. Once again, looking at the why something worked or didn't work. That helps close the circle in terms of the experimental development process and the scientific method. Without that additional step of asking the why, individuals such as the judge have really not a lot of leeway to assess this as anything but trial and error, because the only new information that was generated was something worked or it didn't work. There was no analysis as to why. It's really important that you don't get mixed up and that the trial testimony should not contradict the T661 statements. And again, while allocation methodologies are accepted per the policies, timesheets are the preferred method, particularly with mature organizations. But if you are using timesheets, make sure that they are accurate. So in this case, the judge called them out on having double entry and estimates for some of their time. Now, a point that Dave and I had discussed earlier was there seems to be a bit of a double standard when it comes to specified versus non-specified employees. So specified employees generally are more senior individuals within the organization, and getting a CEO to fill out a timesheet is like herding cats. So the CRA graciously allows many executives to estimate their time, and there's a little more flexibility with these individuals, but it's still good practice to make sure that you have a better understanding of exactly what your time was, because the judge did call them out on this. They indicated that there was the better part of 10% of the time that was estimated, and the judge adjusted some of those numbers accordingly. So those are, in my opinion, the concrete lessons that came out of the concrete case. I'm going to turn this over to Dave to wrap up and add in the what if. So what if they had done things differently? Could you have had a different resolution for the losses here? And if there are any questions, I'll leave that open as well. Dave?